This presentation covers topics related to policing and the law that are found in Chapter 8 of the textbook. And to begin, we have talked about previously that policing falls under the executive branch of government, and the law enforcement function is part of the executive branch's requirements for implementing the law. And just as the power of the police to enforce the law, it comes from the Constitution, so too most of the restrictions that limit the authority of police officers to restrict individual civil liberties in the process of enforcing the law and maintaining social order. And I'm pretty sure I've said this before, but I want to reiterate it because I think it's important to remember that police officers don't have special rights to do anything. Rights belong to individual citizens and are protected by the Constitution of the United States and other laws that fall under it. Rather, police officers are granted special authority under the law to uphold law and order, maintain law and order, but they are also limited by the same legal documents, the Constitution, whatnot, to assure that individual civil rights are respected as much as possible. The majority of the restrictions placed on police authority come from the Bill of Rights, particularly the 4th, 5th, 6th, and 14th Amendments, and I'll talk about each of these a little bit. And I think we talked about them, what was it, chapter 4 or something like that, so you may want to go back and take a quick peek at that for a review if you need to. But the 4th Amendment specifically relates to searches and seizures. Normally we have a right to privacy and our individual bodies, our personal property, our communications, our personal papers and documents, electronic communications, and that sort of thing. So the 4th Amendment says that the police cannot violate that unless they have a warrant or some other legal justification that we'll talk about more in a second, and that the people are protected from unreasonable searches and seizures. Now, the 4th Amendment doesn't specify exactly what constitutes an unreasonable search and seizure. So the courts have to kind of make those interpretations through case law on a case-by-case basis in certain circumstances. But generally speaking, the police have to have some standard of evidentiary proof to do certain searches and seizures under the law. The 5th Amendment, for policing purposes, primarily focuses on protection from self-incrimination. 6th Amendment is the right of the accused to have an attorney. And then we have the 14th Amendment, which I think we talked about before as well, but the 14th Amendment was a Reconstruction era amendment following the U.S. Civil War. And the purpose of the 14th Amendment was to assure that freed slaves in the southern United States were clearly granted legal protections under the Constitution that had previously been denied to them. And what the Section 1 of the 14th Amendment says, no state can make or enforce any law which abridges the privileges or immunities of citizens of the United States. So if you're a citizen of the U.S., the state, no state, federal government included, cannot make or enforce a law that limits the privileges or immunities of that all of us share. All right, you can't target specific groups. In this case, it was free blacks, but this applies to all social groups. No state shall deprive any person, any individual, not just a citizen, any person, of life, liberty, or property without due process of law. And we've talked about due process before, but this is all of the legal procedural safeguards that the law requires us to provide everybody who comes under the scope of criminal justice authority and any government authority, to be quite honest. We have to provide every person due process, regardless of whether they're a citizen or not. And nor can we deny any person within the jurisdiction of the United States equal protection of the law. Again, this applies to everybody. Citizens, non-citizens, undocumented immigrants, if you are physically inside the jurisdictional boundaries of the United States of America, you are entitled to equal protection of the laws, which includes due process. And I know this is not a politically popular topic for a lot of people in our society, but this is settled case law. It's been this way since the late 1800s. So the police are obligated, and the criminal justice system is obligated to provide due process to everybody equally inside the United States. So the first topic we'll talk about is search and seizure. And searches and seizures are things that the police do on a regular, ongoing basis, daily. And this can be something as simple as a traffic stop, pulling your car over, or stopping you on the street to ask you questions. Those are all examples of seizures. Or doing a search. So they may pat down your pockets to make sure you don't have any weapons on you. Or they may end up searching your car or your home in the more extreme cases. Again, the Fourth Amendment protects us from unreasonable searches and seizures. And so then we have to know what police actions are reasonable, what violations of our protection from search and seizure are reasonable. And the courts have gone through a lot of case law over the past 2+ centuries to answer this question. But the shortest answer for now is that police officers have to meet certain standards of evidentiary proof, or burdens of proof, which we talked about previously. And generally speaking, officers must have either reasonable suspicion or probable cause, depending on what they want to do. Okay? Reasonable suspicion is going to be required for evidentiary detentions, Terry stops, things like that. Probable cause is going to be required to make arrests and get search warrants. The Fourth Amendment is worded in such a way that a warrant, an arrest warrant or a search warrant, is always the preferred method whenever possible to assure that a person's Fourth Amendment rights are protected. So in an ideal world, anytime the police wanted to seize a person or search them or their home or their property or whatever, they would go get a warrant signed by a judge, right? And I'll talk about why it's not like that here in a second. But why is it that way? Well, when you go through the warrant process, it assures that the officer has probable cause. When an officer gets a warrant, they have to provide a probable cause statement or a narrative that documents all the facts about the case that they're investigating, that clearly connects a specific individual to the case, and or specifically outlines what evidence is believed to be at a particular place at a particular time. Okay? And so by doing that, the police have an opportunity to go in front of a judge, an impartial judge, and say, look, these are the facts of the case. This is why we think Bob Smith is involved in this armed robbery case, and we believe that Bob has money and other evidence hidden in his apartment, at this address or whatever. And so that's what the particularity piece is about, that the police have to be able to be particular about who it is that they're wanting to seize or arrest. And if they're wanting to search someplace, they have to be specific about where this location is. And different states kind of do this differently, but it is not uncommon for search warrants to require very specific, detailed descriptions of the location itself. So let's say Bob Smith, that you're wanting to search his apartment, and he lives at 1964 Oak Street in Billings, right? And you would have to put in there that the house is a single family residence with gray wooden siding, a black shingle roof, a white door, flanked by windows with the numbers 1964 clearly marked on the front of the house, or something like that, so that there's no question what house you're wanting to search. And then in it, you have to specify that what items you believe are there that need to be seized as evidence. And that way the judge can look at it, say, yes, I agree. The judge will sign off on it. And once that signature's on the warrant, then the officer can go and legally execute that warrant, knowing that they had adequate probable cause as required under the Fourth Amendment, right? And so for this to happen, the officer has to swear an oath. This is required by the Fourth Amendment. And when serving the warrant, it has to appear valid on its face, meaning that it has to, by all accounts, look like it's a legitimate, legally written and filed warrant that has been signed by an actual judge, something like that. And so all of that is put into place to protect the individual rights to privacy and their freedom that's protected by the Fourth Amendment. Now, like I said, in an ideal world, you would always get a warrant to make an arrest or search a place or seize evidence, right? But pragmatically, that's not always the best approach, or it's not the easiest approach. And that really, if we expected the police to go and get a warrant every single time they needed to search and seize people and property, that's all they would be doing. Warrants take time, and you have to find a judge, and the judge has to review it and do all that stuff. So it's a timely or a time-consuming process in a lot of cases. In response to that, the courts have created a wide variety of warrant exceptions that give the police a little more latitude to do basic searches and seizures without the problem of going and getting a warrant ahead of time. And one of the most common warrant exceptions is consent. So consent is golden. When I was in policing, this is what I was trained, and this is what I trained people. If you can get legitimate consent to do something, you're golden. You don't need probable cause. You don't need reasonable suspicion. You don't need a warrant. You don't need anything. If you go and ask and say, hey, do you mind if I pat you down? And they say, sure, you can pat them down. And they don't really have a legal defense to it later on, saying you violated their rights. No, they gave you consent. Do you mind if I check your car, make sure you don't have any drugs or weapons in there? No, sure, go ahead, officer. Then you're golden. Do you mind if I come in and look around a little bit? They say, sure, you're fine. So if an officer gets consent and it's legitimate consent that wasn't coerced, then by and large, that's kind of like the keys to the kingdom when it comes to search and seizure, right? Another exception, one last thing about consent. The other key piece of this is that the person who gives consent can revoke that consent at any time. So let's say I get stopped by the police for speeding or something, and they ask if they could search my car, and I say, sure, go ahead. And partway through it, I'm like, this is taking too long, and this is kind of a pain in the butt, and I don't really want them going through my stuff anymore. I can say, officer, this search is done. I'm withdrawing consent. You need to get out of my car. And unless the police have already come up with some other evidence that justifies probable cause to keep us searching, they are required to stop. And same for your home or your person or whatever. All right. You give consent, but you can revoke it. And if the police haven't come up with additional evidence to justify holding you further, in the meantime, once you have revoked consent, they are obligated to stop doing whatever it is that they're doing or release you or whatever. All right. So the next exception is exigent circumstances or emergency circumstances, where life or evidence or property or something is in imminent jeopardy if the police don't do whatever it is they need to do without delay, and that stopping to get a warrant would cause damage or loss of life or whatever. So an example might be an officer's in a foot chase and is not stopping, and the suspect runs into an apartment. The officer can run in after him without a warrant or without consent, because we don't know if that's their home. We don't know if that person might be armed or trying to barricade themselves in a house or whatever. Now, the key here is, as soon as the exigent circumstance is over, they have to stop and get a warrant. So let's say in this scenario I just gave you, they chase a guy into an apartment, they apprehend that person, they are required to make the arrest and take that person out of the residence immediately. And then if they need to go back in there, they either need to get consent or a warrant. Now, if they happen to be in there and see something going on, that's kind of a different situation, but I'll get to that in a minute. Other exigent circumstances are you get to a home, you get a call to a domestic violence case, you get to the home, you hear people screaming inside, and it sounds like a physical fight going on. You can force entry to go in there and protect someone's life and safety if you need to, things like that. The next one are investigatory stops or Terry stops. And basically, these are brief, limited detentions that give an officer an opportunity to investigate suspicious circumstances to determine whether or not a crime is being committed. All right. And the Supreme Court said that in these cases, warrants are not required, as long as the officer has reasonable, articulable suspicion that a person is either getting ready to commit a crime, is in the process of committing a crime, or has just completed a crime and is in the process of getting away. If the officer can articulate very specific facts that justify their suspicion that this person's involved in a criminal act, they can detain you against your will to investigate further. And the purpose of that is to determine whether or not their suspicion is valid and determine whether or not they have probable cause to justify an arrest. If within that brief detention period they're unable to come up with probable cause to make the arrest, they are required to let you go. And they can't hold you for an extraordinary period of time. All right. There's no set time limit for a Terry stop, but it has to be a reasonable amount of time for you to do your investigation and either make the arrest or cut them loose, one or the two. And the reason this is called a Terry stop is because of the court case Terry versus Ohio, which talked about this issue of stop and frisk, where an officer can stop you to investigate suspicious circumstances, but they may not automatically be able to pat you down for weapons unless they have additional reasonable suspicion that they can articulate that leads them to believe that the person has a weapon on them, and that they then can be patted down. Their outer clothing can be patted down to make sure they don't have a gun or a knife or something like that. You've probably seen some of the Fourth Amendment auditors, they call them, on social media, where they'll go and stand and videotape or whatever, and then the police will ask them for ID, and they'll say, what's your articulable suspicion that I'm involved in a crime? That's part of this Terry stop, investigatory stop stuff. All right. And that's where that all kind of comes from. The next exception are automobile searches. Under the Carroll Doctrine, that was another Supreme Court case. Essentially, the Supreme Court said that officers don't need to get a warrant for searching an automobile on a public roadway, as long as they have probable cause to believe that there's evidence of a crime in that vehicle. And the reason they made that argument was due to expediency, public safety, and the fact that cars can easily be transported and taken away. And so if a police officer needs to search a vehicle for evidence, as long as they've got probable cause, they can search that car without consent and without a warrant. Now, again, ideally, the officer would get consent if you're thinking about it from a legal standpoint. And if you're stopped and the police ask to search your vehicle, you have the constitutional right to say, no, officer, I don't consent to a search of my vehicle. And the Supreme Courts have said, or the Supreme Court has said, that that cannot be used as evidence to justify reasonable suspicion. So, yeah. Related to that is search. Other thing about automobile searches under the case law. If an officer is searching the vehicle for evidence, they are able to search anywhere inside the passenger compartment that they need to look for whatever it is they believe is there. So if it's a weapon or drugs is usually the case. Basically, they can search anywhere inside the passenger compartment of that vehicle. There's some case law that suggests that they can even search inside bags, backpacks, purses, things that are in the vehicle, even if they belong to passengers. But again, there's some little nuances there. And again, I'm not a lawyer, so don't take any of this as legal advice. The next warrant exception is search incident to arrest. If the police arrest you, they are able to search your body, all your clothing, any bags, backpacks, briefcases, anything you have on that you're carrying with you, to look for evidence, weapons, anything like that. Search incident to arrest. It's all, good to go. If you're in a vehicle, they can search anywhere inside the passenger compartment that they need to look for evidence or weapons as part of that search incident to arrest. And if you are in a home, a private residence, and you're arrested in there, there's a thing called the wingspan rule that basically says the police can search your person and anywhere around the immediate area where they encountered you. So let's say they came in and you were sitting in a chair in front of your TV. Your wingspan would be anywhere around and under the chair, in the cushions, in the side table drawer next to the TV or next to your chair and stuff like that. Or if they arrest you, they get you and you've been in your bedroom, they can look in your nightstand or whatever. But it's within immediate reach. The next one is plain view. Anything an officer sees in plain view is fair game without a warrant. They don't have to go get a warrant. If they see it with their eyes, it's fair game. The caveat to that is the officer must be where they are legally at the time they see it. So for instance, going back to my earlier exigent circumstances example, the officer chases a person into somebody else's apartment to make the arrest under exigent circumstances, and while they're inside there, they see that the homeowner has a meth lab going in the kitchen. As they run by, they see all the meth lab going and all that. Well, that's considered plain view because the officer was legally in the home under exigent circumstances and now sees evidence of another crime going on there. They can then act on that. Now, ideally, what they would do is secure the scene, get a search warrant, and go back, and do all that. But it's fair game. Or if you're in your private home and you're standing there smoking methamphetamine out of a meth pipe in your living room of your home, and you're standing in front of an open window and the police happen to be driving down a public roadway and can see in your window and see what you're doing, that's considered plain view as well. What the police cannot do is like walk up to the side of your house and peek in your windows and things like that. Okay, that's called curtilage. The area around your home, that's considered private, protected, just like the inside of your home would be. So they can't do that. But anyway, if it's plain view and the officer's allowed to be there, it's fair game. Abandoned property is another exception. If it's property that is lost or abandoned in a public area or wherever, then the police can seize that without a warrant and they can search it without a warrant to identify the owner, or assure that there's not like explosives in it or anything. And if they find any contraband in it, that is seized without a warrant, and if they determine who it belongs to, you could be arrested. And then another warrant exception are border searches. the Supreme Court has been very clear that as you cross the international border into the United States, you can be subject to pretty extensive searches and extensively long seizures as part of that process, even without probable cause. Once you're away from the border, the courts have said that reasonable suspicion is generally required, except for permanently stationed immigration checkpoints. If there's a permanent checkpoint there, they can stop you and do whatever it is they need to do within reason. It's not quite as extensive as at the border itself, but beyond that, they have to have at least reasonable suspicion to investigate you for immigration violations. Another one that's not on here is DUI checkpoints are similar. That and there's some case law around that basically an argument can be made that if the police can justify putting up a DUI checkpoint, that they're allowed to stop vehicles at random and yada, 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 without warrants. So these are all really common warrant exceptions here, and these are, again, in place so the police can more effectively do their job in a timely manner without tying up resources of the court. Now, let's talk interrogation. The Fifth and Sixth Amendments apply to police questioning and interrogation. And police questioning and interrogation are two separate things. The police can question you. There's consensual questioning. Literally, the police can walk up to you at any moment and say, hey, do you mind if I ask you a few questions? And you have a legal constitutional right to say, officer, no, I don't want to talk to you. And the police cannot hold you there. The police can also question you as part of a Terry stop or an investigatory stop as long as they have reasonable suspicion. You are not obligated to answer any questions, but they can ask you questions under those circumstances. You don't have to answer it again. And then there are interrogation or custodial interrogations where you are under arrest or you are being detained to such a degree that it is a de facto arrest. And if the police are going to ask you any kind of incriminating questions while you're in their physical custody or under arrest, they are required to read you your Miranda right or your Miranda warning. All right. So on TV, and you're familiar with the Miranda warning most likely. And it's not generally like it is on television, where on TV you see the cops get out and say, Susan Johnson, you're under arrest for the murder of Bob Smith. Anything you say can and will be used against you in court. And they start reading Miranda. That's not how it works. They can, but they're not obligated to. And the case comes out of Miranda versus Arizona, which was a Supreme Court case where Ernesto Miranda was arrested for kidnapping and rape. And during the interrogation, he made a confession. And later on, they challenged that the confession should not be allowed as evidence because he didn't know that he had the right to remain silent and things like that. And ultimately, the Supreme Court agreed. And their argument was essentially that taking someone's liberty away from them is important enough of an issue that we are going to require the police to notify you of your constitutional rights so that you can make the best decision you feel for yourself when being questioned by the police. Because there are cases where the police have, basically kind of intimidated people into confessing to crimes that they didn't commit, or you have people who maybe have cognitive disabilities or mental illness or things like that that don't really fully understand what their rights are, that the police have some obligation as agents of the state to uphold civil liberties and due process, right? And so if you are being interrogated where the police are asking you for incriminating statements that will be used as evidence against you, you have to be given a Miranda warning. And that warning can be provided verbally. They can read it to you, and or they can give it to you in writing. And more often than not, it's going to be both. And then following the warning itself, they have to ask 2 qualifying questions. They have to ask, do you understand your rights as I've given them to you? And you have to show that the person was knowing and intelligently able to understand those rights that were given to them. And do you waive those rights and agree to answer any questions? And you have to get a positive, voluntary waiver of the warning at that point. It has to be clear and unequivocal waiver. That if the person says, no, I am not speaking to you, I want to talk to my lawyer, that's a clear assertion of their Miranda rights. If at any point during the interrogation, the suspect says, officer, I'm done talking to you, I'm not going to answer any more questions until I talk to a lawyer. The police have to stop at that point. Okay? And so the key here is that if a person's interrogated, did the police give them their proper Miranda warning? Was the person able to really understand what that warning means? And did they fully and voluntarily waive their rights? Okay. So how this is going to work is that if an officer wants to interrogate you while you're in custody, they will most likely provide a written Miranda warning document similar to this one. I don't recall what department this was, but this is pretty typical of what you would see. And it's going to look at the top. It tells the place where this is being done, because it may not necessarily be at the police station, your case number, the date and time when this is interrogation and the warning is being provided, and then the listing of the individual Miranda rights. These are designated by the Supreme Court in the case law what those rights must be. The specific wording is not specified, but generally these are kind of the accepted legal rights that are written out. They're vetted and done by attorneys and yada, yada, yada. And so the suspect will be presented this document. The officer will look at this at the same time and read these off to them and say, you have a right to remain silent. Anything you say can and will be used against you in court. You have a right to talk to a lawyer and have them present with you while you're being questioned. If you can't afford to hire an attorney, one will be appointed to represent you before any questioning if you wish. And you could decide at any time to exercise these rights and not answer any questions or make any statements. And to the right-hand side of this particular form has blanks for right here, has blanks for the suspect or the individual to initial each block, showing that they have been heard and understood these. And then you have the actual waiver itself here towards the bottom. And it says, I've read the statement. I understand what my rights are. I'm willing to make a statement and answer questions. I do not want a lawyer at this time. I understand and know what I'm doing. No promises or threats have been made to me, and no pressure or coercion of any kind has been used. So that gets to the knowingly and intelligently and voluntarily securing the waiver. Then you'll have witnesses, 1 or 2, the date and time it's signed, the signature of the suspect, their name and address, phone number, social security number. Can you read and write? Yes or no? If they put no, then you need to make sure that you've documented that you read this to them very clearly. What's the highest grade completed in school? If you have somebody who has a 3rd grade education and that's it, which is more common in the past than today, that's important. They may not be able to fully have an actual waiver of their rights because they may not be able to knowingly and intelligently have a waiver, if that makes sense. And so this document, once it's all signed, becomes part of the case file and is essentially a piece of evidence that goes to court later on if a charge is made. And so that's how the Miranda warning works. Now, what I used to do as a cop, I carried a card that the state provided. When I was in the police academy, they gave us this card that had the Miranda warning written on it with the waiver questions. I laminated it and carried it in my pocket my entire career. And if I made an arrest and needed to do Miranda, I would take that card out and read it off that card. I had memorized it. I knew it back and front, but I wanted to do it exactly the same way every time, so there was never a question that if I got to court and the defense attorney said, "Officer, did you give my client their Miranda warning?" I could say, "Yes, I did." And they would ask, "What did you say to them?" I could then pull that card out of my pocket and say, "I read it off this card, word for word, right here. This is exactly what I read to them." And ideally, I would have dash camera video or audio recording, or today it would be body cam footage that would document that as well. So that was kind of how I did it. So some other considerations related to the Miranda case and Miranda warnings. Invoking the right to remain silent cannot be used as evidence of guilt. This is the same for refusing to consent to search. Supreme Court has been very clear that invoking your own constitutionally protected rights cannot be used as evidence against you. The police cannot say, "Well, we thought it was suspicious because they chose not to talk to us. Well, we thought that was suspicious that they wouldn't let us search their car." The courts have said that's not admissible. That's not suspicion. That's, that's them exercising their legal rights. Juveniles are also legally entitled to receive Miranda warnings. And courts have recognized that juveniles may lack the ability to fully understand the Miranda rights and the consequences of waiving them. That could require maybe you have to have a parent or an agent of the juvenile services system or somebody or an attorney or somebody to be there with the juvenile to make sure that they get a waiver or whatever. Some states also do require you to read a Miranda warning to juveniles immediately upon detention. So, in Kentucky, it was like that. We would arrest a 16-year-old kid for shoplifting or whatever, and we were immediately required to read them Miranda, even if we weren't going to ask any questions. Some exceptions to the Miranda requirement include booking questions, routine booking questions. So if you get arrested, they take you to the detention center. They're going to have a booking sheet that they fill out that just documents your existence and your personal information. Miranda is not required. You are legally obligated to answer those questions. If you don't, they're going to hold you until either you do answer them or they're able to positively identify you. And there are basic questions like, your name, date of birth, where you were born, what's your address, where do you work, height, weight, eye color, hair color, scars, marks, tattoos, things like that. In undercover operations, the police are not required to give you Miranda, because under those investigations, the undercover operations, you do not have, as a civilian or an individual, do not believe you are in custody. So if you choose to say incriminating stuff to a person you don't realize is a cop, that's on you. Spontaneous and voluntary utterances, or basically these are statements that are unsolicited by police. Anything you say just randomly and the police hear it or are able to record it, it's fair game. You do not have any legal expectation of Miranda protection for stuff that you voluntarily say on your own. So an example of this would be a case I worked with a DUI. A guy was a habitual DUI offender. He had hit and almost killed a city road worker, road crew person. And when I tried to talk to him, he wouldn't answer any questions at all. He never said he wanted a lawyer, but he wouldn't answer any of my questions. But when I left the room to get some coffee for myself, because I'm a coffee addict, we left the camera going, and I got him water too. And while I was out of the room, he kept saying out loud, he's like, "Oh, I can't believe I did this. I hope I didn't kill that person. I knew I shouldn't have been driving like that. God, that was so stupid." All of that was fair game. That was evidence against him because it was spontaneous and voluntary. utterances. Um, Sometimes you'll have the same thing while they're going to jail. They're sitting in the back of the car. I wouldn't ask them anything. I would just let them talk, and they'd say all kinds of stuff. So my non-legal, non-attorney advice for you is if you ever get arrested, just be quiet. Because anything you say, they're going to use it. Roadside questioning of motorists. If you are being stopped for a traffic violation or whatever, they do not have to give you Miranda. And again, we talked about Terry stops. If it's an investigative stop, they can ask you basic investigative questions. But as soon as they believe you are going to be arrested, or you believe you're under arrest because there's enough cops there and it's obviously a custodial interrogation, at that point, they have to give you Miranda. But by and large, they do not. You don't have to answer, and they can't use that as evidence against you. And so, given these legal requirements, what happens if the police don't follow them? Well, Mapp versus Ohio is a Supreme Court case that provided one of the main legal remedies related to unlawful searches, unlawful seizures, and unlawful interrogations. And in Mapp versus Ohio, um, the Supreme Court ruled that the police conducted a warrantless search on Mapp's home in search for obscene material and created a remedy that's now called the exclusionary rule that says any illegally obtained evidence found during an unlawful search or an unlawful interrogation will be excluded from court and cannot be used as evidence. Um, and related to the exclusionary rule is the fruit of the poisonous tree doctrine, which says that any evidence of a crime that you gain after the fact, after the original unlawful search or unlawful seizure or unlawful interrogation, anything that comes after that is also going to be excluded. So a good example of this would be an officer sees a car that they think they want to stop so they can search it for drugs. They don't really have a traffic violation or any other reason, legal reason to stop the car. They just do it. And in the course of the stop, they search the car for drugs, and they end up finding a dead body in the trunk of the car. And they arrest this person for murder, right? Well, if the defense attorney recognizes that there was no justification for the original stop, then therefore, under the exclusionary rule and the fruit of the poisonous tree doctrine, everything that came after that is also excluded. So you would lose the search would be unlawful, the dead body's unlawful, or cannot be admitted as evidence, and therefore the charges have to be dropped, right? Or a tangible, real-world example was when I worked in Florida. There was, some of y'all may be familiar with it or maybe not. There used to be a video series called Girls Gone Wild where they would send film crews to spring break locations and they would have college-age women get intoxicated and have them do all sorts of, what's the word I want to use? Racy, kind of spicy kind of things on camera, and then they make videos and sell them on TV. Well, they came to Panama City one year for spring break, and long story short, it turned out that some of the females that they approached at spring break and filmed were underage. And they had given 15 and 16-year-old girls alcohol and cocaine, got them to undress, engage in sexual activity in a condo that they had rented. The sheriff's department investigated it. They got a search warrant. They executed the search warrant. They seized a bunch of videos, drug evidence, videos of other underage people being exploited, stolen property, all kinds of stuff. They seized a private jet and they seized like really expensive cars and camera equipment and computer stuff, all this stuff. Well, it turns out that the probable cause that the investigator had used to get the search warrant was falsified. And so under the exclusionary rule, because the warrant was invalid, then all of the physical evidence they had seized in response to the initial complaint was then excluded, and all of the other evidence that they had seized showing other crimes was also excluded, and then all of the property that they had seized as evidence and for asset forfeiture had to be returned. And because it had been 2 or 3 years after the fact and this property hadn't been properly maintained, the sheriff's department had to pony up like millions of dollars to compensate them for the lost value in their jet and their sports cars and all that crap. And then you have these young ladies who were victimized who could not get any justice through the justice system because the sheriff's department investigator lied on the affidavit, the search warrant was invalid, and then the exclusionary rule and the poisonous tree doctrine kick in. Hopefully that makes sense. Another related concept is called the good faith exception, that as long as the police genuinely believe that they were acting in good faith, that they were doing a legal search or a legal seizure, if they can justify that and it's rational and reasonable and makes sense, then the judge can rule that the evidence can still be admitted under the good faith exception. But this is more uncommon, but it's there. And so to wrap this all up, as I said, law enforcement officers have special authority to restrict the constitutional liberties of private individuals, but those actions must be made in accordance with the Constitution, statutory law, and case law. Officers do have to meet specific standards of evidentiary proof to conduct non-consensual searches and seizures, and it's always preferable to get the warrant if you can, but you don't have to if one of those warrant exceptions applies that we talked about. And that the police have an obligation ethically and legally to assure that due process rights are upheld when conducting their investigations, and failure to do so can result in legal remedies, including the exclusionary rule, having evidence kicked out, losing a case, and they could also theoretically in certain cases be criminally prosecuted for misconduct and or sued civilly for misconduct. So that's the intro to CJ overview of legal issues related to policing. You get more of that later on in some of the other classes in more detail, but hopefully this was informative. And if you have questions, let me know.